Hi, I'm Candace Slusher with Slusher Consulting, and today I want to talk about advanced directives and do not resuscitate orders. Whenever you sign up a client, and if you're in a regulated state, you probably are required to ask about these things, but even in a non-regulated state, you do want to know what the situation is with your clients. Most of them are senior, quite elderly, and hopefully there is some sort of plan in place for what might happen when they can't make a decision anymore. And you need to have that written down in your file, in your client records. So it is ideal to ask about whether or not they have any advanced directives. Now, advanced directives includes a lot of things. It is the living will, which is a document that specifically states which life-saving measures the client wishes to have, that they've already had this conversation with someone, that they've talked about it, that they have it written down, what their wishes are so that they're known. It also includes power of attorney, both medical power of attorney and durable or financial power of attorney. And medical means this person is allowed to make decisions about my health, about my care, if and when I am incapacitated to make those decisions. Now, some people get a little worried and don't designate a power of attorney because they're afraid that their family might take over for them and make decisions for them. But legally, the power of attorney only steps in and takes place if and when the client can no longer make those decisions for themselves. And usually that means that they have a diagnosis or that something happened. They could have had a stroke. They could have, maybe they have some mild to moderate dementia, and it's time that maybe they're making bad decisions for themselves. But this is to give someone else permission. I trust this person. It just says I trust this person to make decisions if I can't. So you might need to educate your clients. It doesn't mean that they're taking over. It doesn't mean that they're the boss of you. You are still in charge of your own life and situation. But when you're no longer able to make these decisions, this is the person that you say is designated to do so for me. And hospitals and medical personnel will often ask for that, especially if the person obviously has dementia or some sort of cognitive or physical diagnosis that keeps them from being, incapacitates them. So the other thing, though, is durable or financial power of attorney, which is someone who can talk to the bank, deal with my money. And that one is not always as important for you. As sometimes the medical and durable would be the same person, but sometimes maybe the person has multiple family members and one person is in charge of the money and the other person is in charge of the care. And that's okay. You need to know if someone else is paying the bill other than the client or the medical power of attorney. You do need to know that information. And if they have it set up, they're usually happy to tell you. Then there is do not resuscitate order, which is different from just the living will. Okay, so living will is, if you're saying I don't want life-saving measures, that could be a feeding tube in your stomach, or that you don't want to be kept alive on a ventilator or by other means. But do not resuscitate means no one is going to perform CPR on you if your heart stops. And they need to hear that. Some people say, oh, just let me go. But unless you have a life-limiting illness, I mean, if you stick a fork in a life socket or something happens and your heart stops, but you're not sick and dying, you sure you don't want to be resuscitated? So sometimes that conversation needs to be had. And most physicians will not sign a do not resuscitate order because that is a physician's order. That's not just a wish. That's not just this is what I want. It's a physician's order, and most doctors won't sign that if there isn't a life-limiting illness. Then there's a difference between an out-of-hospital do not resuscitate or DNR and a regular DNR, because someone might go in for surgery and they always have to ask them, if your heart stops on the surgery table, do you want us to restart it? And some people will say no. And they're like, you know what? Let's just let that. If God's taking me, they're taking me. And that's okay. But that they signed in the hospital or the facility does not translate at home. So when people ask about an out of hospital do not resuscitate order, they need to speak with their physicians about that. It might even be two signatures that's needed, and it needs to be posted somewhere on the wall in their home. Either on, some people put it on the back of the front door or on their bathroom door in the bedroom or their bedroom door, because when emergency services arrive, unless they see a do not resuscitate order, their rule is that they have to perform CPR. Very rarely will they make that exception, um, but that is usually the rule. So, living will, power of attorney, do not resuscitate orders. Those are the things that most advanced directives cover. That's usually it. Now, it's not necessarily a responsibility as a home care, administrator to have all these resources. You don't have to give them paperwork and packets and teach them everything about it. That's not really your responsibility. It's okay to have some information you can give them or give them a brief description, but you don't have to go through all that with them. There is an organization called Five Wishes that you can look up online, and they can download some paperwork or order it, a little booklet, and they can fill those out. And it is a real layman's term way to talk about end-of-life decisions. I used that with my father, and it did make that conversation easier. There are lots of free resources online, and in each state, whatever state you're in, you could actually look up free downloadable power of attorney, living will documentation, and probably download something that'll do. It's not usually some big secret. You don't have to hire an attorney. And if the family situation is pretty simple, there's one kid or there's two and they pretty much agree on everything, then something downloadable is sufficient. It usually requires signature of two witnesses who are not listed or not family, or you could have it notarized. Either way, and that would be honored in most hospitals and with doctors' offices. But if it's a complex family, if there's a lot of adult children, a lot of grandkids, people don't necessarily agree on everything, then your best recommendation is a local attorney, maybe an elder law attorney who can help them get that all together, because then it probably does need to be a little more legal and official. The bottom line is you as an agency are going to honor any advanced directives that your client has set forth. Now, that doesn't mean that you have to carry anything out or withhold anything. Just simply say, we'll honor whatever you want to do, because you're non-medical, right? Now, you may have a policy that says your caregivers perform CPR, or that they do not perform CPR. They just call 911 and might follow dispatch instructions, things like that. But those are conversations you need to have with the client when you admit them. One last thing, guardianships. A guardianship does not necessarily fall under advanced directives. A guardianship means someone went to court. Someone disagreed about this client's care, about their needs. Sometimes it's about finances. Sometimes it's about medical care. Usually it's around money. But almost always, if there's a guardianship in place, that means there's somebody that you're not allowed to talk to, or that is not allowed to make any decisions or have input on that client's care. And so you definitely want to have a copy of the guardianship in your file. Everyone in your office needs to know that if that nephew calls, you can't talk to him. But that means there was some sort of legal battle and a court ordered this guardianship. A judge made a decision on who is making those decisions and taking care of the client's affairs. So you must honor that. That one's a pretty big deal. You don't necessarily have to have a copy of the powers of attorney in your records if you don't want to, but you need to at least write down who it is so that you know who to call. I hope this has been helpful to you.